So Section 26.1 requires trade unions, before they charge dues, to provide information on how dues will be utilized. And if the dues are deducted by the employer and then remitted to the union must inform the employer of an election or revocation by the employee as it relates to union dues. There's also prohibitions against any disciplinary measures by the trade union against the member arising from their election or revocation.
So on December 7th, the federal government announced that it was planning to propose regulations under Part 2 of the Canada Labour Code to make COVID-19 vaccination mandatory in all federally regulated workplaces covered by Part 2. And it also stated that Indigenous governing bodies and First Nations band councils would be exempted from the regulations, and that the government will work with Indigenous groups to provide information on the regulations should they wish to follow the same approach as the government at their discretion. So what the government did is the ESDC, so the labor program, published a consultation paper. It's called COVID-19 Vaccination Regulations, and you can access it and see the questions that have been posed by the government. So we should expect these regulations, as announced, as in early 2022.
The court essentially presumes that the arbitrator has exclusive jurisdiction where the labor legislation has a mandatory resolution clause, and many labor statutes across the country do have those types of clauses. So there's that presumption that's built in there. Of course, necessary to have a careful analysis of the applicable legislation to make the final determination, but that presumption is interesting. And then in the second case, where there might be two tribunals with concurrent jurisdiction, it's the decision maker must decide whether to exercise its jurisdiction in that case, looking at exclusive jurisdiction, statutory language, collective agreement. So you've got the step where, is it the arbitrator? The arbitrator presumably has exclusive jurisdiction. Has the legislature carved into that jurisdiction to grant another tribunal jurisdiction? If there is that concurrent jurisdiction, then you get to the step 2, which still leaves some discretion on whether or not to exercise the discretion.